Welcome and thank you for joining us for part 4 of our 4-part on-demand learning series focused on estate planning. My name is Becky Weiss and I am an instructor and research specialist at the Howard County Library System. We are excited to partner with King Hall LLC, a law firm located in Ellicott City, Maryland, to provide you with this educational resource. Today, 2 of King Hall's associate attorneys, Kelly Renaud and Michael Dubé, will discuss guardianship.
Thank you, Becky. Most people think of an estate plan as simply planning for the distribution of your assets after you have passed through the creation of a will. A well-drafted plan consists of more than a will and should also include an advance medical directive, power of attorney, and in some situations, a trust. The goal is to have a plan that is usable, flexible, and meets your needs for a long time to come. Together, this set of documents allows you to safeguard your goals, protect your values, and avoid or at least delay guardianship.
In this series, Kelly and I will discuss many of the estate planning options. In this 4th and final installment of our presentation series, we'll be discussing guardianship. Guardianship is often a consequence of poor or a lack of estate planning, but this is not the only case in which guardianship is employed. Guardianship is an extremely powerful legal tool that comes with significant consequences for both the alleged adult disabled individual and the proposed guardian.
So what is guardianship? In Maryland, adult guardianship is a legal process that is most often used when a vulnerable person, that is, the alleged disabled person, seems to be in need of protection. For some reason, someone finds themselves in a state of incapacity and cannot advocate for themselves. Maybe this person has had a serious accident and is in the hospital. Or it could be that the person has been declining mentally, maybe physically, and has declined to the point where they can no longer make responsible decisions regarding their well-being. When this happens, someone else needs to step in on their behalf. While there are often options as to how this can be done, one way is through guardianship, which must be requested through the court, and only a court can appoint someone as a guardian. A guardianship order essentially strips the new ward of their right to make many important decisions on their own behalf. It shifts that responsibility to the newly appointed guardian. Examples of these important decisions include deciding where the ward lives, consenting to medical care, managing the ward's assets. This is a drastic measure, and as such is considered an option of last resort to be used when less restrictive alternatives, if any, have been tried and failed. Whenever the Maryland court appoints a guardian, the guardian acts as the arm of the court because the court is actually the ultimate guardian. The appointed guardian is expected to report every year to the court, and if that guardian is not doing their job, they will be removed. In Maryland, there are 2 kinds of guardianship. Michael, will you explain this to us?
Certainly. So as stated, there are 2 types of guardianship in Maryland. First, we will discuss guardianship of the person. A person is considered legally disabled or lacks legal capacity when he or she lacks sufficient understanding or ability to make or communicate responsible decisions concerning himself or herself, such as provisions for healthcare, food, clothing, or shelter. This disability can be because of a mental disability, a disease, habitual drunkenness, or addiction to drugs. Establishing a guardianship of a person is typical in the following situations: where the alleged disabled person failed to execute an advance medical directive and certain medical procedures are necessary that require consent, and 2, when more than one person in the family wants to care for an alleged disabled person and the family is unable to resolve this conflict on its own. Maryland's guardianship laws are actually some of the most comprehensive in the country. Maryland affords alleged disabled individuals a host of protections, including a right to counsel, a right to a hearing, which can be a jury trial when guardianship of the person is sought, a right to demand discovery and demand the presence of physicians at trial, and courts will employ the highest evidentiary standard for civil matters, which is the clear and convincing evidence standard when a hearing is held on a guardianship matter. Now on to guardianship of property. A guardian of the property will act as a fiduciary. The court will establish guardianship for a person's property when it can be shown that the person has or may be entitled to property or benefits that require proper management, and that person is unable to effectively manage that property because of a physical or mental disability or disease, or in several other specific circumstances. When there is a medical condition present, this standard can usually be met by merely showing that the person can no longer identify and manage their own property, and is thus incapable of handling their own bank accounts, bills, and mail responsibly. It is at this juncture that the court can appoint a guardian to act on behalf of the court to manage a disabled person's property. However, you must still show the court that there are no less restrictive alternatives available, as we have discussed in earlier presentations. Kelly, can you discuss what those less restrictive alternatives are?
Yes. So you may think about the scenario where a loved one lands in the hospital suddenly and you're called to their side and the doctors are asking you questions, asking for consent for different procedures. And the doctors will accept that loved one's decisions. That loved one is acting as a surrogate decision maker. While this can operate as a less restrictive alternative in an emergency situation, it does not go the distance in that it does not ultimately protect your values and protect your goals. And it does not operate outside of that emergency situation. What can is the existence of an advanced medical directive. This is a legal document that allows you to identify your healthcare agent. This is somebody that you would trust to step in your shoes and make decisions on your behalf if it ever became necessary. They could consult with your healthcare team and help formulate a plan for your care. In so doing, there would not be a need, or at least you could delay any potential need for a guardian of the person. In this way, you keep those rights. You are never stripped of those rights to ultimately make your own decisions on your behalf when or if you were to become competent again. When we draft advanced medical directives, we include additional sections besides the healthcare agent section. We include what is sometimes known as a living will. This is end of life planning. That is expressing your wishes on how you would like to be treated in those dire situations where there's really no hope of recovery. Do you want every possible medical avenue to be explored for your survival? Or do you want nothing to be done and you would prefer to have death occur naturally or somewhere in between? We also include post-death instructions. This tells people what you want to have happen to your body after you've passed. It includes organ donation, perhaps funeral arrangements, or celebration of life preferences. Having a comprehensive document like this just ensures that you have the best possible chance of having your goals and your values honored, even if you are not able to advocate and express them yourself in the heat of the moment. The other legal document that is very useful is a financial power of attorney. This allows you to name or nominate a financial agent. That agent would be able to stand in your shoes and manage your finances when you are unable to. This operates as a less restrictive alternative by avoiding guardianship of the property. Here you have a legal document already in place that tells everybody who it is that you want to step in your shoes and help you. Now, I would note here that there are a number of financial institutions that would perhaps not accept a general power of attorney, but instead insist that you fill out their own specific power of attorney. So when executing a general financial power of attorney, I would also encourage you to check in with each of your financial institutions to make sure that they will accept that or would prefer to have you fill out their own power of attorney. In both cases, the agents that you name, just keep in mind what you're asking these people to do. They could possibly be placed in very difficult situations, in very emotional situations. You want to make sure that they're up to the task. So bear that in mind when you're selecting your agents. In our practice, we often represent the alleged disabled person, which is the person facing possible guardianship. Many times we realize that if these people had executed an AMD and a POA when they were healthier, then they would have had agents at the ready to step in and make decisions when they were not able to do so themselves. Guardianship could have been avoided.
To wrap this up, we recommend that whatever planning documents you have, safeguard the originals and share your intentions, just as you did with the trusts and wills. Make copies and share your document with your named agents, healthcare providers, financial institutions, and so on. This way, if you face an emergency, all relevant parties will know what to do.
All right, thanks so much, Kelly and Michael. We have a few questions before we wrap up. Our first one, when should I execute an advance medical directive and financial power of attorney?
So while you're in good health, both mentally and physically, is the best time to execute an advanced medical directive and the power of attorney. And honestly, you should do it as soon as you practically can. I know Kelly and I both have our documents done, and I'm sure we probably force our loved ones to do the same thing at this point. But setting up an advanced medical directive or a power of attorney well in advance of issues related to one's faculties can avoid a significant amount of headache down the road. And it could, in fact, will, in most cases, moot the need for guardianship completely because the documents control for what guardianship is trying to solve. To give you an example of how this often plays out, imagine the following scenario. You're in an accident, perhaps a car or motorcycle accident. You're then hospitalized. You're unable to communicate for whatever reason. You do not have an advanced medical directive or power of attorney. So the hospital is trying to get in contact with your next of kin, perhaps your spouse or another close family member. This is what Kelly was talking about earlier with the surrogate decision maker sort of aspect of things. And let's say you don't have family or they can't be located reasonably. The facility or hospital then has to find a way to secure consent for your treatment, safely discharge you, and of course be paid. In order to do so, they'll have to file for guardianship if these documents don't exist and they cannot locate a surrogate decision maker, even if they're filing for guardianship reluctantly, which is often the case we find in our practice. So the whole aforementioned unfortunate scenario, with the exception of the accident itself, can be avoided if you just have these documents done ahead of time. The reality is, if you want any control when your capacity is diminished, you must have these documents. So if there is no guiding document, you are relying on family members carrying out your wishes, which often leads to litigation among loved ones, unnecessary stress, and of course, unnecessary expense.
All right, our next question, how is incapacity determined?
Well, for guardianship, it requires two healthcare professionals to evaluate the alleged disabled person. And there are only a handful of healthcare professionals that are allowed to do this under Maryland law. That is any medical doctor, a psychologist, a nurse practitioner, which was recently added this past year, and a licensed certified social worker at the clinical level. The evaluation of the potential ward, at least one evaluation must take place within 21 days of filing the petition for guardianship. And this is because the court wants to know the status of the person now, not 6 months ago, because situations can and do change. It's important to distinguish between capacity and competency. Capacity you can think of as functional. Do I have the capacity to sign my name versus do I have the capacity to write a check? This is determined by a medical professional, whereas competency is more of a global assessment, and this is actually a legal assessment that is done by the judge.
Our last question, who can be appointed as a guardian?
So the individual is appointed as guardian. The priority is set by law, but can be skipped for good cause. So often it's a family member or a close friend who's appointed as a guardian. However, a third party can be appointed under certain circumstances. Oftentimes, I think Kelly and I see this probably the most when there is intense conflict between the would-be family or friend guardians, and then the court says, okay, none of you are being appointed guardian. We're appointing a third-party attorney to do it to sort of avoid future conflict. However, for example, if there is no family or friend who's willing or able, one could become a ward of the state. This happens more often than one may think. And this is why having your wishes spelled out clearly in those advanced medical directives or power of attorneys is so important, because you can actually name a proposed guardian in those documents themselves. So you can avoid a lot of headache. Again, I know I'm repeating myself, but really those documents are critical.
All right, we hope that you found this presentation helpful. This was the last in our series. The other three focused on a will-based estate plan, a trust-based estate plan, and the different types of trusts. You are more than welcome to contact our office if you have additional questions or would like assistance. Thanks again.
Thank you.